Hello, and welcome to AIM International's preparatory tutorials for the Information Certification exam. I'm Steve Weissman, Principal Consultant at Holly Group and a certified AIM training instructor in the realm of content, process, and information management. I'll be your guide as we review the exam's major domains of expertise, and I'll tell you all you need to know to earn that passing grade. Today's subject is data privacy, a key part of this special certification, which AIM created to support you as you solve your organization's existing information-related problems and plan for its future. For 60 years, AIM has been the leading nonprofit association helping users understand how to best manage documents, content records, and business processes. This module is part of the Secure and Preserve Knowledge domain, one of 6 within the certification program. In it, we will cover some of the major regulatory considerations associated with data privacy, including protecting financial data, protecting health data, protecting personal data, and security protocols. Data privacy centers on the ability to share data while protecting personally identifiable information, and concerns about it exist wherever that kind of information is collected and stored, in digital form or otherwise. Improper or non-existent disclosure control can be the root cause for problems here, which can arise in the context of information of all different kinds: healthcare records, criminal justice proceedings, financial transactions, biological traits, residence records, privacy breaches, personal internet data, and the list goes on. By far the areas most focused upon, and thus subject to the most regulatory attention, are financial data privacy, healthcare privacy, and personal data privacy, especially in this online age. Information about a person's financial transactions, including the amount of assets, positions held in stocks or funds, outstanding debts, and purchases, can be quite sensitive. And of course, if criminals gain access to the likes of credit card and bank account numbers, fraud and identity theft are very real possibilities. Less directly invasive, but no less scary, is the fact that information about a person's purchases can reveal a great deal about his or her history, such as places visited, people contacted, products used, activities engaged in, or medications used. Many corporations no doubt ache to use this information to target individuals with customized marketing campaigns, and some, like Google and its ability to tailor ads based on an analysis of Gmail's contents, are known to be proceeding down this path already. The U.S. Right to Financial Privacy Act is a federal law that gives the customers of financial institutions the right to some level of privacy from government searches. Before the act was passed, the government did not have to tell customers that it was accessing their records, and customers did not have the right to prevent it. It was passed after the Supreme Court held that financial records are the property of the financial institution with which they're held, not the property of the customer. The Health Insurance Portability and Accountability Act of 1996, known as HIPAA, among other provisions, regulates the use and disclosure of certain information held by covered entities, generally healthcare clearinghouses, employer-sponsored health plans, health insurers, and medical service providers that engage in certain transactions. It establishes regulations for the use and disclosure of protected health information, which is any information held by a covered entity which concerns healthcare status, provision of healthcare, or payment for healthcare that can be linked to an individual. This is interpreted rather broadly and includes any part of an individual's medical record or payment history. HIPAA further requires covered entities to take reasonable steps to ensure the confidentiality of communications with individuals, to keep track of disclosures, and to notify individuals of uses of their protected information. Covered entities also must document privacy policies and procedures, and must appoint a privacy official and a contact person responsible for receiving complaints, and it must train all members of their workforce in procedures regarding protected information. So as you see, this arm of the law is fairly long. But the agency chartered with handling the complaints, the Department of Health and Human Services Office for Civil Rights, has a long backlog, and says the Wall Street Journal ignores most complaints. So much for practical implementation. The right to personal privacy, though guaranteed by the Constitution as interpreted by the U.S. Supreme Court, is an implicit right in the United States. This is not the case in Europe, where it's an explicit right. This means that the country takes what it calls a sectoral approach to data protection legislation, relying on a combination of legislation, regulation, and self-regulation rather than governmental regulation alone. While the European Union has the Data Protection Directive on its books, the U.S. has no single data protection law that's comparable. Privacy legislation in the states tends to be adopted on an ad hoc basis, arising only when certain sectors and circumstances require, such as with the Video Privacy Protection Act of 1988, the Fair Credit Reporting Act, and the 2010 Massachusetts Data Privacy Regulation. Though not legislative, one set of U.S. guidelines serving to govern fair information practices in an electronic marketplace is the Federal Trade Commission's collection of Fair Information Practice Principles, the core of which address these elements. Notice and awareness, under which consumers should be given notice of an entity's information practices before any personal information is collected. Choice and consent, or giving consumers options to control whether and how their data is used, most typically opt-in and opt-out. Access and participation, which addresses not only a consumer's ability to view the data collected, but also to verify and contest its accuracy in an inexpensive and timely manner. Integrity and security, to ensure that the data collected is accurate and protected. And enforcement and redress, in the form of 1. Self-regulation by the information collectors or an appointed regulatory body, 2. Private remedies that give civil causes of action for individuals whose information has been misused to sue violators, and 3. Government enforcement, which can include civil and criminal penalties. The existence of privacy laws and guidelines means organizations must safeguard the personal data with which they are entrusted. This is accomplished largely through the use of high-technology security protocols, a term that generally refers to a suite of components that work in tandem and, when used with a communications protocol, provides secure delivery of data between two parties. For example, the 802.11i standard provides these functions for wireless LANs. For the web, SSL is widely used to provide authentication and encryption in order to send sensitive data such as credit card numbers to a vendor. The primary components of a security protocol are as follows. Access control authenticates user identity and grants entry to specific resources based on permissions and policies. Encryption algorithms are formulas that turn ordinary data or plain text into a secret code known as a ciphertext. Each algorithm uses a string of bits known as a key to perform the calculations. The larger the key, the more bits, the greater the number of potential patterns that can be created, and the harder it is to break the code and descramble its contents. Key management involves the creation, distribution, and maintenance of a secret cryptographic key or keys, and makes them available to all parties to the information exchange. Message integrity ensures that a transmitted message is valid and that an encrypted message has not been tampered with. The most common approach is to use a one-way hash function that combines all the bytes in the message with a secret key and produces a message digest that's impossible to reverse. In this module, we covered the major regulatory considerations associated with data privacy, including protecting financial data, protecting health data, protecting personal data, and security protocols. Next, you may wish to review the module on procedures for protecting personal information and for administration rights management and auditing. The material you have just reviewed is part of a broader program of study that prepares you to take the Information Certification exam. This proctored test consists of 100 multiple-choice questions and is delivered electronically by Prometric. You'll have 2 hours to complete it, and upon passing, you'll earn a professional certification that's valid for 3 years. For more information, please visit www.aim.org/certification. Thank you.